Bada bing. Great.
All right. I want to welcome everyone that's here today and those that are going to see it on Zoom. It will also be recorded and we will have it on the website for those that aren't able to be here today or to follow it on Zoom today. Before I introduce James, I want to just mention that Megan couldn't be here today because she had a sudden death in her family. But I was so glad that James was able to do this for us today. Do you want to go ahead and introduce yourself?
Sure. Well, thank you for having me. I'm sorry that it's under the circumstances, but I'm happy to be here. My name is James Nici, N-I-C-I is how you spell my last name. I'm an estate planning and tax attorney. I've been in Naples for 29, almost 30 years. This is my area of expertise, and so I focus my entire practice on estate planning and taxation. So I'm happy to be here.
And I'm an estate planning attorney as well, but in Massachusetts. So anyway, so thank you, James, so much for filling in at the last minute. We really appreciate it. And I plan on inviting Megan in the fall to come because there were so many people that are interested in it today.
Great.
So
okay.
ahead.
Well, hopefully I don't let you down, and the filling in will be just as good as having Megan here. So I'll get started. The topic for today, as I understood it, was just a basic overview of estate planning. So that's what we're going to cover. I put together a slide presentation. So for those of you on Zoom, obviously you'll see it. Everyone else in the room here, you'll see what's on the big screen. We're going to go through the slides. The slides aren't the kind of slides that you have to read everything that's on there. Basically, it's a topic, and then I'm going to discuss things. So I've given you some handouts that you've received when you first got here, my business card, some other information, as well as that one-page seminar survey. So if you have a minute as we go through, please fill that out. And then as I cover each of the topics today, you'll see them mentioned on the survey sheet. If it's something you're interested in or want more information, just check that off on the survey sheet. And I offer everyone an opportunity, anyone that attends here in person, or those of you that are on Zoom that couldn't be here in person, you get a free consultation to come in for 30 minutes to discuss how these topics might apply to your situation. Okay, so if you're interested in that, for those of you in the room, just fill out that survey sheet and turn it in, and we'll make sure to make an appointment. And for those of you online, the information you see on Zoom will have my name of the firm, phone number. You can call and make an appointment as well. Okay, so let's get right into it. So the first topic is, why should you plan? I mean, what's the point? Why are we here? And so I try to narrow it down to three things. First, you want to plan so you can protect yourself. Obviously, it's self-serving, but it's important. You want to make sure you protect yourself first. Second, you want to protect your loved ones, whether that's a spouse or children, grandchildren, whoever it may be. It could even be charities if you have charities, if you don't have family to take care of. So protect your first, make sure your documents are in order, protect the loved ones when you're not around. And third, protect your assets. So you want to be able to not only protect yourself, your family, but also your assets. And we're going to go through how you might do that today. As we go through, I'm going to go over some basic estate planning documents. And so the paper I have, you can take some notes or think about things as we go through. If you have a question, you have a choice. You can write it down and then hold it until the end, and we can cover it that way. Or if it's specific to a particular topic, just raise your hand and I'll be happy to answer it as we go. All I ask is that as you ask your question, try not to make it so specific, just applying to you, knowing that you'll have an opportunity for a free consultation to ask all of your private questions in private. So if it's a general question like, I heard this, fine. But if it's, I have a daughter or a son who, and I need to know this, I'm probably going to tell you to save that question for the private consultation. That way we don't get bogged down and we don't have to discuss your private affairs in public, okay? So your estate planning documents, first and foremost, will consist of an advance directive. An advance directive is a document where you designate someone to make medical decisions for you if you can't act. Typically in a husband and wife situation, you'd have the husband name the wife name the husband, and then who would you pick if the spouse could not serve? Could be a child, could be two kids, could be a brother, sister, whomever. The idea is if something happens to you and you cannot speak to the doctors about your medical intent, your medical care, you need to have that in place ahead of time. So that's very, very important. Second document, you need a durable general power of attorney. That document is a power of attorney in which you designate someone to make business or financial decisions for you if you can't act. Again, same thing. If something should happen to you, who's going to deal with the club, deal with your taxes, deal with the bank and your investments? Typically, in a husband and wife situation, you'd have the spouse first. But again, we need a second person. Could be a child, family member, something else. So we want to have your medical issues covered, and we want to have your financial issues covered. So that's those two. The third, everybody needs a last will and testament. Some people's provisions are different than others, but everybody should have one. And as you probably know, a will designates who should get what, how, and when you pass away. So that, again, in a husband and wife situation, you might provide that everything passes to your spouse. If your spouse isn't living, you might want it to pass to your children. And then the question is, how do your children get it? Do you leave something for grandkids if you have them? Do you want to leave something to charity? Those kind of things. If you don't have kids, who's going to get it? And you also need to decide who the personal representative will be. In Florida, we don't have executors. And the term in Florida is personal representative, but it's the same thing as an executor up north. That is the person that you designate to be in charge of your affairs when you're gone, to carry out your wishes under your will. Okay? The fourth document that most of my clients have is what's called a revocable trust or a revocable living trust. That document is something where it's what we would refer to as a will substitute. You still have a will, but most of your assets would be contained or owned by that revocable trust and would pass pursuant to the terms of that revocable trust when you die. So oftentimes I have husbands and wives that have revocable trusts. They name husband and wife as co-trustees of each other's trust. So no matter which trust owns assets, husband and wife can still get access to them. So I describe it as joint with respect to access to the funds or assets, but separate between husband and wife. And why would we want to separate it? Well, in some cases, it could be a second marriage where they have separate assets and they want to keep it separate. In some cases, we need to separate things for tax purposes. So having a revocable trust really does two main things. One, it avoids probate on the assets that are titled in the name of that revocable trust. And two, it avoids a guardianship, that in the event the person gets Alzheimer's or a stroke or something and can't take care of themselves, assets in the revocable trust will continue to be managed for that person by their successor trustee for the rest of their life, can pay for their care, can pay their bills. Okay, all of these four documents fit hand in hand, and not everybody has all four. Most people have at least three: the advance directive, the power of attorney, and the will. Some people will add a revocable trust, depends on your situation. And some people add a fifth document. That fifth document is called a beneficiary designation. Now, we're all probably familiar with beneficiary designation on maybe a life insurance policy or an IRA or something like that, where you fill out a form, you submit it to the company, the insurance company, maybe the bank or the investment company, and that will spell out who is to inherit that specific asset when you pass away. And you will usually have a primary and a contingent beneficiary. Primary is typically a spouse in a husband and wife situation. Contingent could be the kids. It's really important when you do a beneficiary designation, along with the other documents that are listed, that they are coordinated. And I'll give you an example. Sometimes we have situations in which a husband and wife will just name, say, their spouse as the primary beneficiary of their life insurance policy or their IRA, and they don't name a contingent beneficiary. And then when one spouse dies, the surviving spouse doesn't change the beneficiary designation. It still says spouse who's now deceased, but they want the assets to go to the kids. So now when the person passes away, the kids come to me and say, okay, mom or dad, there's a survivor. They have this IRA, and we think we're the beneficiaries. And if the spouse or survivor didn't fix it, we find out that it was naming the deceased person. And if you name the deceased person and you don't have a contingent, then the problem is most custodians or most banks, institutions, life insurance companies will say the beneficiary then defaults to your estate, which means now that life insurance or that IRA becomes an asset of your probate estate, and I have to probate that asset, even if that person has a revocable trust, because the IRA or life insurance that wasn't properly designated with the beneficiary can't get into that trust unless the beneficiary is right. So it's really very important if we're going to do a plan, and this is what I do for all my clients, is I try to be comprehensive. yes, have a medical directive and a power of attorney and have your will and maybe a revocable trust, but we also need to make sure beneficiary designations are coordinated with the documents we prepare. If they don't match, then we have a problem. Now, there's a reason that you could have them different. For example, you might have a situation in which it's a second marriage and the revocable trust says my house and my bank account goes to my spouse, but maybe my insurance goes to my children. And so the beneficiary designation might send assets to one beneficiary and the revocable trust could send it to another. That's okay if that's what the person intended. What we don't want is an accidental designation. And I've seen this in situations where, unfortunately, where there is a divorce and the form designated a former spouse as a beneficiary. And that does not make anybody happy, except for maybe the former spouse when someone dies and the new spouse is expecting to inherit that life insurance, but it's still named the former spouse on there and it wasn't fixed. So again, really, I can't stress that enough. Making sure the beneficiary designations that you have are coordinated with the documents you prepare. It's not good enough just to have documents. And just by a show of hands, how many people here are Florida residents? I'm guessing just about everybody. Okay. So for those of you that are, fantastic, you know, it's wonderful to be in Florida. I'm a board certified Florida attorney, so I can help Florida people. The people who are in the room or watching on Zoom who may not be Florida residents, you need to deal with this in the state in which you're domiciled. Now, I think you should become a Florida resident. There's lots of benefits, okay? Not just the sunshine, but there are lots of other benefits. But if you are a resident of a different state and you're not domiciled in Florida, these same concepts apply to you, but you'll have to get them dealt with in the state in which you're domiciled, okay? If you're a Florida person, obviously I can meet with you, have a consultation, review this, review your plan, make sure all of these things are coordinated. So far, are there any questions? And I don't know if we're able to field questions through Zoom or not, but if not, are there any questions in the room about what I've covered so far? No? Got a good crowd. Everybody's listening, understanding, and ready for trivia later. So, all right, we'll move on to the next topic because I know I have a hard stop at 4:45 or 5, so everybody can get to the clubhouse. Now, what I have on the screen now, title of assets is critical. This is very important. How you have your assets titled, just like how you have your beneficiaries designated, is of critical importance. Simple example. If I have a bank account that I own joint with my son, but I want that bank account to pass equally to my 3 children when I die. When I die, if my son is a joint owner with rights of survivorship, who do you think is going to get that bank account? That son. He's a joint owner with rights of survivorship. It won't pass to all 3. Now, I don't generally recommend that my clients own assets jointly with their child because there's a creditor protection problem there. But if you're going to name a single beneficiary or a joint owner, you need to understand that has to be coordinated. If an asset is expected to be under a trust, let's say I have a business, and in my revocable trust, I direct that my business is to go to, say, 2 of my children and not to a 3rd, because maybe those 2 kids are in the business. Well, then if I move that business into my trust and the trust provides that it goes to those 2 children, it will. But if I have my business owned jointly with my 3rd child, even though my trust says it goes to the other 2, if it's jointly owned with rights of survivorship, it's going to pass. So how the assets are titled are very important. Same thing for real estate. Example, people have houses sometimes here and up north. If you have a house up north, you want to have it in a revocable trust so you avoid a probate up north, especially if you're a Florida resident. If you're domiciled in Florida, we want to avoid a probate here in, let's say, Massachusetts. So getting that asset retitled into the name of your revocable trust, so it's then governed by the provisions of that revocable trust, is really important. Now, I'm a Florida lawyer, so I cannot prepare a Massachusetts or a Minnesota, Ohio deed. So what I do is I draft the documents for my clients here, and then we coordinate with a lawyer that's licensed in the state that you own real estate, explain what needs to be done, and then that lawyer does the work to do a new deed to properly retitle your assets. Is that clear? I want to make sure no matter what I say today that you get this part above all else, which is you need to make sure that how you own your assets, how things are titled, will supersede your legal documents. Yes, ma'am.
It's not quite ask if it was clear, it's not quite clear, especially relative to a home.
Up north or here?
Up north.
Okay,
So if the home is in one person's name, but when they die, obviously it's gonna go to someone else.
it will obviously go to someone else after they die. The question is who?
Right.
So the concern is, let's use an example. We have a husband and wife, and the husband wants assets. He owns the house up north, and he wants that home to go to his spouse. Say it's a second marriage, to go to his spouse in a trust, so that spouse can use that home for the rest of their life. But then when the spouse dies, he wants the value of that home or its proceeds to go to his children, or vice versa. Well, if the husband leaves that house in his individual name, in order to do that, I have to open a probate in Florida, open a probate up north to get it into his trust to then do that. What I would prefer to do is have the trust say what it says, speak to the northern attorney so that husband changes the title through a new deed by putting the house into the trust while he's alive. So now when he dies, I don't have a probate in Florida. I don't have a probate up north. And that house can then go into the trust for the surviving spouse for their life and then to his children. What would be worse is what if that person has the asset joint with their spouse, but intends for it to go into the trust for the spouse and then to his kids? Well, if it's joint with rights to survivorship and he dies, the asset will go directly to the wife. And once she gets it, those are not her children. She's not obligated to leave it to them. And so I see that sometimes in second marriages where assets of one spouse or the other are not titled correctly to coordinate with their documents, so that it's one thing to say, you know, it's a second marriage and we're going to have each other use our assets for our lifetimes. But when the second one dies, we want certain assets to go to my kids, certain assets to go to your kids. In those kind of circumstances, this is absolutely critical. If you don't do it right, someone is going to be disappointed. Because if it doesn't go, like you said, it will go to someone. We just want it to make sure that it goes to the someone that you want it to go to. Okay, does that answer the question or help clarify that? So again, it's just very, very important. It applies to bank accounts, real estate, investments, IRA, anything. The key is you have to make sure you title those assets correctly so it fits with the plan. When I meet with clients, and if you come in for a free consultation, you'll see this. I send out a questionnaire ahead of time, and I ask clients to tell me about themselves, their spouse, their kids, their assets. And sometimes people will say, oh, I don't want to tell you about my assets. And I say, okay, well, understand, if you don't tell me about your assets, it's really hard for me to give you all my advice. And sometimes they don't want to do that, which I understand. If you don't want to, that's fine. Just understand I'm going to be limited in how I can help you. It's like going to the doctor and say, it hurts here. And the doctor says, well, we'd like to draw some blood, maybe get an x-ray. Oh, no blood, no x-ray. What's wrong with me? Now we can joke. And if I said that, everyone's going to laugh, right? No doctor is going to say, well, we're going to operate to figure it out. They wouldn't do that. They're going to do tests and things to figure out what the issue is. And then with that information, give you the proper advice so then you can make an informed decision. It's no different for me. Okay. So I always tell clients, the more information you can give accurately and clearly, then the more advice I can give more accurately and clearly. Make sense? Okay. Any other questions about that topic? Yes, sir.
Ken,
As far as living
Ken,
trust,
can you just?
Oh, I'm sorry. I can repeat the questions if you want. Since I'm mic'd up, if you ask, I'll repeat it. But go
okay,
ahead.
as far as living trust goes, is it possible to put assets other than a house or real estate, for instance, 401 money or IRA money or other instruments of
In the
asset.
trust.
Right.
Okay. So I'll repeat the question. Can you put other assets in the trust, assets like 401ks, IRAs, life insurance, or annuities? Generally, the answer is no. That's why you have a beneficiary designation. And I always describe it that your revocable trust assets are here, which is your personal assets, and your beneficiary designation type assets, 401ks, IRAs, life insurance, and annuities, are over here. Now, how do I get these assets and these assets to be disposed of according to the same plan? I link the two with the beneficiary designation. And that's really important. So I don't necessarily change the title to your 401k. I can't. But I would update the beneficiary designation on your 401k to coordinate with the plan. So if it's supposed to pass to a spouse or to a child or one kid or two kids or in trust for someone, whatever you want to do, we make sure that it fits, that it matches. And that's done with the beneficiary designation. And that's very common. Many clients will come in and say, oh, I've got that covered already. And I say, okay, yes, but if your 401k just says to a spouse or to a child, that's usually a direct outright distribution. But if your revocable trust says, I want to have it protected, and I'll get to that on the next slide. If I want to have it protected, what can I do? And that's a good transition to the next topic. What I refer to as a creditor protected inheritance. And I'll just give you a simple example. I ask this to all my clients when we have a meeting. If you're going to leave money to someone, let's say your children, you have two basic choices. You can leave money to them outright, in which case they're going to get their inheritance, get a check or cash or whatever it may be, and put it in their bank account. It's their money. They do whatever they want with. The problem is, if I'm your child and I inherit that money and it goes in my bank account and I get into a car accident or I file bankruptcy or I get a divorce, that asset may be exposed to those creditors. So I ask my clients, when you pass away and you want your heirs, whoever they may be, to inherit, would you like to leave it to them in a way that's protected from their creditors? Which is where you get the creditor protected inheritance. Would you like to leave them an inheritance that's protected from creditors or not? Most of my clients answer, yes, I want to protect. I don't want my money, whatever the amount is, to go to my kid so that my kid gets into a car accident and someone takes all of the money. Then my kid doesn't have any inheritance. Most people don't know you can protect it. So what I often do is explain, yes, you can. Here's how. And most of my clients will opt for a creditor protected inheritance. All that means is that we create a trust for the child and the child can be in charge of it so that when you die and the money goes to that heir, child, spouse, whoever, it's in a trust, protected from those outside people who are trying to take it. And that's a perfect reason why we do a beneficiary designation. If I've got an investment account, it's in my name, I move it into my revocable trust, it's over here. And I say, when I die, I want it to go to my 3 kids equally. And I want it to be protected from creditors. So I create a creditor protected inheritance trust under my revocable trust for my kids. And I have a 401k or an IRA or insurance over here. If I don't do a beneficiary designation that matches and makes it link, these assets will not be protected from creditors. And for many of my clients, it's either their house and or their retirement plan that is their largest asset. And so I want to make sure that we coordinate those beneficiary designations so that if you want creditor protection on everything that's here, you also get creditor protection on everything that's here. Okay, so it's really important. I can't change the owner to the trust, but I must update the beneficiary designation. Okay, does that answer your question?
Yes, thank you. Just a follow-up though. The assets that are held in the living trust, for instance, your home,
Okay.
primarily. Let's say one of the spouses has to go to memory care and, you know, that's a significant drain and something happens. Are your assets in the living trust protected from that situation?
Okay, I'll repeat the question and simplify it a little bit. Are my assets in my revocable trust protected in such a way so that they won't be lost if I have to go to a nursing home? Okay, that's part of the next set of slides. Okay. So, and I promise, thanks Dad for the question. I promise that you're not a plant, that obviously that's going to be what I'm going to cover. So I'm going to hold off on the answer until I get there. Okay.
Put a pin in it.
All right. So the creditor protection inheritance, I summarize it simply. You can leave an inheritance to your heirs, to your children or whomever. So it protects it against car accidents, bankruptcy, any other lawsuits or divorce. And when I give this option to most of my clients, they want this protection. Many times, if people are from Northeast or Midwest, they have an estate plan that just says, leave the money outright to the children. And that's okay if that's what you want. But my recommendation is you always want to protect assets from creditors. That's really important. I want to distinguish a creditor protected inheritance for your children or heirs from asset protection planning, because I do that too. So when I think of asset protection planning, I'm thinking of how do I protect your assets while you're alive from people or entities that try to get it. And this is what we tie in with the nursing home. So if we're trying to protect it from your creditors, who are some of your creditors? I don't know, it could be credit cards, bankruptcy, or nursing home. So there are certain exemptions in the state of Florida where your assets, just by the nature of the asset, they are protected from creditors. I don't have to do anything fancy, it's in the law. One is your home. So your principal Florida residence, your homestead, is protected from creditors if you're a Florida resident. Now, how many of you here have a home here, Florida resident, and you've filed for homestead? Everybody, I hope. Okay. If you own a home in Florida and you're a Florida domiciliary, this is your main residence, you need to make sure it's homesteaded. And you have to do that before March 1. And so you have about a week to get it taken care of for this year if you haven't. So make sure you have homestead on your home. It has lots of benefits, but one of them obviously is it's protected from creditors. Another asset that's exempt from creditors is life insurance. So if you have the cash value of a life insurance policy that you own, creditors can't take that cash value. If you have an IRA, IRAs are exempt from creditors in Florida. So that's protected asset. And 401ks, like you mentioned, that's protected from creditors. So when I'm dealing with many of my clients, their house, their retirement plans, most of their assets will be protected from creditors. So really, there isn't much in the way of asset protection I need to do for them, except when it comes to the question that you raised, which is, what if I want to protect it from nursing home costs? So it's a little different. Protection from creditors means if I get into a car accident and I have $1 million IRA and someone sues me for $1 million and they get a judgment, can they force me to go into my IRA and give them the $1 million? The answer is no. Not if it's my IRA, I'm a Florida resident, I get the creditor protection, even if I'm, quote, guilty of having had that accident, okay? It's different with nursing home costs. If I have $1 million IRA and it's, quote, protected from creditors, the government doesn't really care. And here's why they don't care. If you need nursing home costs, there's really 3 ways to pay. First, with your money, you can self-pay. So if you have money and need to go to a nursing home, skilled care, memory care, whatever it may be, they send you a bill for the month, you write them a check. It's that simple. It's just self-pay. Government's not involved, insurance isn't involved. However, some people may have long-term care. Anybody here have a long-term care policy? Just one. So most people don't, maybe 2. Most people don't. Those used to be very popular and cheap. And the insurance companies figured out we're living longer and people are actually using them. And some of those companies no longer sell that product because it's too expensive and they lose money. So I see fewer and fewer people having a long-term care product. So if you don't have long-term care, which is basically, quote, nursing home insurance, well, if you don't have that as a source to pay, you're back to private pay. Or you can get on Medicaid. Now, Medicaid is a government program. It's a federal program administered by the states, which basically says if you need nursing home care, the state will pick up the cost. But they will only pick up the cost if you're very poor. Now, we all have different definitions of poor, but for this purpose, you have to have less than $2,000 of assets. I'd call that pretty poor. So most of us in the room have more than $2,000 in assets. So we're not going to qualify for Medicaid. So if I have more than $2,000 of assets and I don't have long-term care insurance, the only thing left is to private pay. So for some people who are concerned about what you raised, they can do planning in advance of having to go to a nursing home using trusts. Not a revocable trust. That's still your asset. That's still available. It still counts. It's what's called a countable or available resource. You can create a special kind of trust, which I'm not going to get into today. It's a little bit beyond the scope of today. If it's something you're interested in, write that down on the list or on your survey sheet, and we can talk about it. But it's a special Medicaid trust that you can transfer assets to it. And then if you need Medicaid 5 years or more later, the assets you've transferred to that trust will not count. So you could take $1 million, not an IRA, because that's taxable, but you could take $1 million bank account, brokerage account, transfer it to that trust. And then if you needed Medicaid 5 years from now, needed to go to a nursing home, that $1 million could still be available for you and your spouse, but it wouldn't count. So it wouldn't count towards that $2,000 limit. okay? But you have to plan 5 years in advance.
And it could be more now. It's 5 years now, but just be prepared. They're talking about
Yeah.
7 years, maybe even 10 years. So I always told my clients, because I did elder law, and I was in the National Academy of Elder Law Attorneys, and I would say to people, you need to plan early.
Right.
Because at some point, it isn't worth spending the money to have an irrevocable trust if in fact you're not
going to make it.
have that.
Right.
Years is really right now, but don't count on that.
Right. There were some rules in the past that were 3, and then 3 became 5. And it could, again, it's real simple. The federal government has a program administered by the states where the states take their money and pay for your care. If the state doesn't have money to pay for all other things, well, what they do is they just change the rules to make it harder for you to get money from the state to pay for your care. It means you have to pay for your care. So I do that kind of thing. I don't do much of that because it does require longer term planning, and many clients don't really want to plan 5, 6, 7 years in advance. It's one thing to plan today for when I am going to die, which could be 10 or 20 years from now. But we all know we're going to die. We don't all know we're going to need a nursing home. And if I get to hold on to my money and plan for what happens when I won't need it, that's easier than taking my money, creating a trust, and getting rid of my money so I don't have it to use. So there's limitations. It's harder. Again, if this is something you're interested in, write it on that survey sheet when you turn it in. We'll make sure to talk about it when we meet. But it's a little bit more involved than I can cover in today's session. Okay, but that was a good question. All right, any questions so far about anything I've covered? Because we're just real close to wrapping up here, and I want to make sure if you have other questions, we get them now. No? Okay. So
I just want to mention, one of the things I did for my children was when they turned 18, they got for their birthday present a healthcare proxy. Because we didn't, an advance directive like in Massachusetts would be only if death was imminent and you didn't want a ventilator or any feeding tube, anything that was going to keep you alive. That's what we called it in Massachusetts. A healthcare proxy would be with regards to just healthcare. So when my kids turned 18, I made sure that I gave them that for their birthday. So that a healthcare proxy where they named me their proxy, and also adorable power of attorney. So those are things you could mention to your children, or you could do it for your grandchildren, but that was their birthday present.
yeah, it's interesting. I think this is something that estate planners do for their kids. For me, I did the same thing. I have 3 children, 21, 19, and 17. And the 2 that are over 18, same thing. It wasn't necessarily a birthday present, but I knew they were going to go off to college. And when you go off to college, colleges seem to think that an 18-year-old is an adult. And even though mom or dad is paying the bills, they don't talk to mom or dad. You have to talk to the kid. So for me, I said, look, I want to make sure, and I explained to my children that if something happens and you're in the hospital at school, they won't talk to me and tell me what's wrong because you're an adult now. So the rule for me was, look, if you want to go off to college when you're 18, you'll have a medical directive and a power of attorney. So if I call the school and need to talk about your bill, tuition, whatever it may be, or you're sick and I did talk to the doctors, I can provide them with a copy of the instrument. They'll talk to me and it doesn't harm you. And typically 18-year-olds don't have any money anyway, and whatever they've got, you probably gave them. So at that point, they don't care. They're happy to let you handle their finances and whatever, because if you're paying the bills, they want to stay in your good graces. So that's how it worked for me. So I have 1 kid left to go. It's my daughter. I'll get back to you on that one to see whether she goes along. The boys were a lot more compliant. Okay, so when we wrap up here, I'm going to just mention the last thing, and that is, and I've got a little handout that you can take to look at, but I created something in 2007 called the Strategic Snapshot. It's part of what I developed called the Strategic Estate Planning System. And basically, there's a little picture here, but you can see a little bit more information on the handout. It is a graphical representation of an estate plan. And what I mean by that is, when I draft legal documents, it's pages and pages of words on paper, could be 100 pages, 200 pages. Most of my clients aren't interested in necessarily reading 150 pages of legalese to figure out what's what. But if I can narrow it down to a 1 or 2 page picture of the medical document, the power of attorney, the will, the trust, what happens if I die? What happens if my spouse dies? What happens when the kids get it? How does the creditor protection work? Where are the assets? How are those assets titled? Are they titled correctly? because there's not only a page that summarizes the legal documents, but a page that summarizes how the assets are titled. That strategic snapshot is something that in the last 17 years or so has proved to be very beneficial for my clients, for their CPAs, for their other advisors, because they get to see it on just a few pages in color, very simple language, boiled down to the essence of what they need without having to read all the legal documents. And so when I have reviews with my clients every couple of years, if they have a strategic snapshot, it makes the review very easy, because we sit down and we don't review the documents. We review the picture. And when we review the picture, it's very clear. Who do you designate to make these decisions first and second? Oh, I named my brother and my brother passed away, so I need to change that. Well, they see it. We just fix it, do a new document, update the snapshot, and they're good. So same thing with assets. If an asset is not titled correctly or the beneficiary designation, well, wait, this says somebody and I don't want to leave it to that person anymore. I need to fix that. They see it on the page. It makes it easier. So it's something I offer as an add-on to an estate plan for my clients. Not everybody does this, but the ones that are interested, they just look at it and say, hey, here's a sample. Do I like what it is? Do I think it's beneficial? And then we do it for them. Okay, so I wanted to explain what that was without getting into too much. Yes, sir.
How do you define high net worth?
It defines, it's however you want to define it. I just had a conversation with someone from Chicago that's head of a family office for ultra high net worth. And so he says, we have some high net worth clients, but most of our clients are ultra high net worth. So I didn't ask him how he defined it, but I said, look, I can represent someone from $100,000 of net worth to several hundred million. And I do. I have clients all in the middle. The way I work, and you'll find this out if you come in for a consultation, is I charge a fixed fee for the documents that you need. If you want to do a strategic snapshot, there's a fixed fee for what you need. So typically, clients that have a higher net worth have more needs. So they need more documents, and therefore they pay a higher fee. Clients that have a lower net worth, they need less documents. Therefore, they pay a lower fee. So I don't really have a definition of high net worth. It used to be anybody over $1 million or $1.2 million, because that was the exemption, 30 years ago when I started. Now the exemption for estate tax is 13.6 million per person. So 2 people is 28 million. So maybe 28 million is now high net worth. So I don't really assign a number to it. I don't get into that per se. I just say, what is it you're trying to accomplish? Can I help you? If I can help you, I will. Here's what it costs. You decide if you want me to do it. Okay. Okay. Any other questions?
What do you recommend your clients? How often do you think they should review their records?
Okay.
2 years or 3 or?
Usually I say between 3 and 5, or if
That's
there's
what I
a
do.
family change.
Oh.
A grandchild is born, God forbid a child passes away,
Mhm.
someone gets sick, someone has a bad medical diagnosis, whatever, you sold a business. If there's a life event, then at the time of the life event. But if life is just kind of cruising along as normal, then about once every 3 years. And again, if you've got a snapshot, that's pretty easy. You come in, we sit down for 15 minutes, we print this out, we look at it, we do a quick review. Here's who you picked for medical, 1 and 2, power of attorney, 1st and 2nd, will, trust, this is what it says. Is everything still good? Here are the assets. Anything changed? Let's look at it. 15 minutes later, if everything's good, you go home. It's like getting a checkup at a doctor. Okay, it's pretty simple. You had a question.
Yes, if you have basically a simple will,
Mhm.
but everything goes to your spouse, your IRA, you've got
Mhm.
beneficiaries, everything, and
Right.
house. Does it have to go to probate in Florida?
No. So let me explain what probate is. So the definition I give for probate is the court supervised disposition of your assets at death. If we have bank accounts owned jointly with rights of survivorship and IRAs and 401ks with spouse as the primary beneficiary, and one spouse dies, the survivor doesn't need the court to supervise that. You go into the IRA custodian, you provide a death certificate and an ID, they roll the IRA over. If it's a house, we do what's called an affidavit of surviving spouse that says your spouse died, we attach a death certificate, you sign it, we record it. You go to the bank on the joint account, bring a death certificate in your ID, they take your spouse off, they put your name on. You don't need a judge or a court to help you do that. So there is no probate. And that's an important distinction. When I go back here in the slide presentation to the 4 documents, okay, or the 5 if you have a beneficiary designation, many of my clients will not have a revocable trust right now. And this is strange. Most of the time, if you go to these kind of presentations around town, the lawyers are going to say everybody needs to have a revocable trust to avoid probate. And it's true that a revocable trust avoids probate. But if I have the scenario that you just explained, which many of my clients are in that situation, husband and wife, they own everything jointly, they're named primary beneficiary on their retirement accounts. Yeah. If I draft a revocable trust for them, what would I put in it? If I'm not going to put anything in it, then why should I charge you to draft it? Right? So many of my clients will come to me with the belief that the only way for them to handle their estate is to have a revocable trust. And oftentimes I say that's not true. That's why I do a consultation. We sit down and discuss what you have, discuss what you want, what are your goals. And if you have what you just described, you'd have an advance directive, a power of attorney, and a will. The will would provide everything to the survivor. You'd own everything jointly with rights of survivorship. Your spouse would be the primary beneficiary. We do a beneficiary designation. If God forbid both of you died together in a car accident, we want to have a contingent and we want it to be protected from creditors. So you'll have 4 of the 5. The one you won't have is a revocable trust because that's not appropriate for you. Now, when one spouse dies and everything switches over to the surviving spouse and there is no spouse to now have it owned jointly with, well, now you can't do that. Now you may need a revocable trust because you don't have a spouse to own it jointly with. And you don't want to own things jointly with your children generally because it exposes your assets to their creditors. And sometimes that's a wake-up call when I hear clients come in and say, I want to add my kid to my deed. Why? Well, my husband died and I have the house now. And if I die, I want it to go to my daughter. She's my only child. And I just want to add her. I said, whoa, that's a bad decision. It's bad for taxes. It's bad for creditors. What do you mean? Well, if you add your kid on your house, I already told you that your house is protected from creditors because it's your homestead. But that house is not your daughter's homestead. So if your daughter gets into a car accident, it's just another piece of real estate, which means if she gets into an accident, her creditor can bring you into the lawsuit, force you to sell your house so that creditor can get the half that belongs to your daughter. That is not a conversation that you want to have. So basically, if that's the case, I either stop the person from adding the child, or if the child's on there, we fix it. Okay? Okay. Any other questions? Because we're basically finished. No?
No.
Okay.
I was going to ask you, do you do prenups at all?
I used to do premarital agreements.
Yeah.
I no longer do them, only because it's become too complicated with changes in marital law. And since a husband and a wife both have to have representation, I generally have to take one of my clients and send them to somebody else, and then it gets a little adversarial. So now I just say, listen, husband, wife, go see marital lawyers, deal with your marital agreement pre or post nup. And when you're done and you've settled your arrangement, bring a copy in and then I'll draft your estate plan to match it. Okay, good question. Okay, yes, sure.
Is a Michigan will honored in Florida?
Okay, the question is a Michigan, or I'll just say, is a will from another state honored in Florida if I move to Florida from wherever that other state is? It's a great question. Some people will phrase it, is the will invalid? The will is not invalid when you move from one state to another. It just may not be interpreted the same way. And I'll give you an example with Michigan with a real case. So in Florida, we know about homestead, and we know that homestead is protected from creditors. Well, there's one way that you can waive that protection when you die, and that is if you have a provision in your will that directs that your homestead should be sold when you die. Example, I had a client come to me and say, I've got a will for Michigan. It says when I die, sell all my assets, divided equally among my 3 kids. I don't need I heard the will is valid in Florida, so I don't need to get it up to date. And I said, it's true, it's still valid, but understand, if one of the assets that you've directed to be sold is your home, you just waived your creditor protection at death on that. What do you mean? Well, let's say you're driving down the road, you have a heart attack, you crash the car, you're in an accident, you injure someone, you die, maybe they die, maybe they don't. They sue your estate. If you have a direction in your Michigan will to sell your assets, and we don't change that now that you're Florida, now your home, when it gets sold, the proceeds of the sale won't go directly to your kids, will be held for that creditor. Whereas if we change your will and just say, my kids get all my assets, don't direct a sale. Well, now, same scenario, heart attack, car accident, injury, lawsuit. Well, now the house, the protection you had while you were living, passes on to your children, and the house goes directly to the kids, creditor gets nothing. So that's a simple example of a real case I had many years ago. At the very least, if you have existing documents from another state, you need to have them reviewed by a Florida attorney to see what needs to be changed. And in most cases, the medical directive, like here, you talked about an advanced directive in Florida, the term advanced directive really encompasses two things: a designation of a healthcare surrogate, which is the healthcare proxy, and a living will, which is pull the plug if I'm terminal. Okay, those two documents in many states are separate. In Florida, we combine them into one and call it an advanced directive. What she was referring to that they called an advanced directive, we call a DNR, a do not resuscitate order. That's very different. So the idea is it's different from state to state. It doesn't mean it's invalid. You just have to have it reviewed to make sure that it achieves the same objective that you thought you were getting there, you get it here.
To attest to a will though here, is it 2 signatures or a notary?
Both. So,
Both.
so
So that's the other thing you have to look at.
yeah, so what she's describing is the execution or the formalities of execution required from state to state are different. In Florida, you have to sign your will in the presence of 2 disinterested witnesses. That's all you need. You sign it at the end with 2 witnesses. However, you should also attach what's called the self-proof affidavit, which means you sign again, the 2 witnesses sign again, and the notary signs. Okay, so some people have a will from up north. It's just signed by the person with 2 witnesses, no notary, no self-proof. It's still valid. It just means when you die and I go to send it to the court will say, well, you better find those 2 witnesses so I can take their oath to make sure that it was done properly. Now, I don't know about you, but oftentimes you can't even read the signature, let alone who it is. And then if you know who they are, how do you find them? They could be deceased. So it becomes a very, very complicated mess when you're talking about a couple $100 to just fix it. And it is much better in most cases to just come in, have a meeting, review it, figure out what needs to be done, fix it, pay for it, and move on with the rest of your life. When I see people trying to not do that, it often means the mess that they bring later is more expensive than if they had just fixed it. Okay. Okay. Yes, sir. Let's go in the very back. I'll get to you. Yeah. Just want to give him a chance too.
I was told that it would be best to put my homes in a trust, multiple states, but
Mhm.
to pass it on to my heirs rather than not.
Okay, so I'll repeat your question for the Zoom people. He was told that he should put all of his residences, both Florida and up north, in a trust. So the answer to that for up north is usually yes, because I'm assuming you're a Florida person. So if you're domiciled in the state of Florida, you're a Florida resident, then your home up north is not your primary residence anymore. It's a secondary home, a vacation home. That should be in your revocable trust in most cases, 100%. Your home in Florida, not so much. So I'll use myself as an example. And that's a good thing to ask anytime you're meeting with a lawyer or a doctor and they give you advice. Ask them how they do it. Okay, that's a good question. So I own a home in Florida. It's in my name. It's not in my trust. Why? Because it's my primary residence. It's my homestead. And there's a procedure to deal with that homestead when I die to get it to my kids so they get the creditor protection that I had while I was alive. I don't get the same benefit if that home is inside my revocable trust. So short answer for you, if you're a Florida resident, I would advise you, your Florida home stays outside your revocable trust. Your northern home goes into your revocable trust because I want to avoid a probate on that northern resident. Okay. If you're not a Florida resident, then you're a resident of where? Illinois. Then your Florida home is not your homestead. Then your Florida home should be in your Illinois revocable trust. You get a Florida lawyer to do the deed, put it in your Illinois revocable trust. And then is what to do with your Illinois property, speak to your Illinois lawyer. Because now it's a totally different set of law. It's Illinois with Florida being the second versus Florida primary and Illinois being second. Okay.
And
Yes,
on
sir.
a homestead in Florida, like I'm a widow, I get extra protection. All I had to do was bring in the death certificate for my husband. So if there's any widows, you do get added.
Yeah, and that's a benefit you get on your property taxes. Okay, you had a question.
Summarize benefits of becoming a Florida resident.
Where do you currently reside? Where's your?
Unfortunately, New Jersey.
Okay, so I keep it simple, and I'll say this a little tongue in cheek. Do you like paying state income tax? There's your reason. I mean, I don't want to be glib about it, but that is simple. Florida does not have a state income tax. Most other states do. In certain circumstances, for example, if you own rental property in New Jersey and that's all of your income, it really doesn't matter. If you live in Florida, you're going to pay New Jersey because the income you earn is New Jersey state income. But most of my clients are not in that situation. Most of my clients are retired. They have Social Security, they have a pension, they have money from a retirement plan, they have dividends and interest. If they become a Florida resident, they don't pay state income tax ever again. And so that is generally the single best. Besides, you don't have to shovel sunshine. Okay. Okay. Any other questions about anything else that we covered or didn't? I know we're running right up against the 5 o'clock limit for trivia. Okay. Any other questions? All right. So I'll end with this. As I said in the beginning, if you want a free consultation, I'll come around and collect the survey sheets. Take a minute. Please be honest about the presentation at the bottom. I've asked you to give me a review. I won't take offense, right? I'm not going to stalk you if you don't like what I said or how I did it, but I do want positive and you know, constructive criticism if you can improve on something. But please do that. Turn it in. I'll come around and collect it. And if you do want a consultation free, just check the box. My assistant will get in touch with you, or you can call my office. It's here in Naples. The number is 239, of course, 449-6150. And you can call that number, schedule an appointment. It's usually a 30-minute free consultation. There's no obligation. You come in, we review what we've talked about, apply it to your situation, tell you what it'll cost to do what you need to do, and then you decide if you want to proceed or not. Okay? All right?
I just want to thank you again. I mean, it was just yesterday that I got the news from Megan, so
Yeah.
I just want to thank James again for doing this with 1 day's notice. So
Yeah,
thank
you're
you.
welcome. Thank you. And if you're done, I'll collect the